Understanding the difference between a will and a living trust. Everyone has heard of a will and a trust, but not everyone knows the differences between them. Both are useful estate planning tools that serve different purposes, and both can work together in the context of a comprehensive estate plan. One main difference between a will and a trust is that a will goes into effect only after you die, while a trust takes effect as soon as it's created. A will is a document that directs who receives your property at your death, and it identifies a person known as a personal representative to carry out your wishes as stated in the will. In contrast, a trust can be used to begin distributing property before death, at death, or even manage assets after death. A trust is a legal arrangement through which a person or an institution such as a bank called a trustee holds legal title for property for another person called a beneficiary. A trust usually has two types of beneficiaries. One type that receives income from the trust during their lifetime, and another type that receives the trust's remaining assets after the income beneficiaries pass. A will covers any property held by you in your individual name when you die. It does not cover property held in joint tenancy, held in a trust, or that has a designated beneficiary, provided the beneficiary is someone other than the estate. A trust, on the other hand, covers only property that has been transferred to the trust. In order for property to be included in a trust, it must be put in the name of the trust. Another difference between wills and trusts is that a will passes through probate. Unlike a will, a trust bypasses probate, and therefore avoids both the cost and delays associated with the probate process. It also remains private, unlike a will, which is a matter of public record. A major difference between wills and trusts is typically cost. Even though more expensive initially, a trust can ultimately be less expensive because it avoids the probate process, provided it's properly drafted and funded. Wills and trusts each have their advantages and disadvantages. For example, a will allows you to name a guardian for your children and to specify funeral arrangements, while a trust does not. On the other hand, a trust can be used to plan for disability or to provide savings on taxes for larger estates. Ultimately, it's up to you and your attorney to decide which of these two methods is best for you based on your individual circumstances. However, each of these differences should be carefully considered as part of your overall decision. For more information, visit our website at www.legacyassuranceplan.com or call us at 844-445-3422.